Hello, everyone. Thank you so much for joining us today. We're delighted to have all of you here, and we want to thank particularly our wonderful panelists, Zoe, Suzanne, Richard, and Terry. Thank you so much for being willing to cooperate with this panel. I'm going to ask that each member of the panel introduce themselves. And first, I'll turn it over to you, Zoe, if you could just let our participants know a bit about your background and how you came to be on the panel.
Sure. Hi. Thanks so much, Susan. My name is Zoe Brennan-Krohn. I use she, her pronouns. I am a staff attorney at the National ACLU Disability Rights Program, and my work focuses a lot on alternatives to guardianship and helping people with disabilities use alternatives like supported decision-making to retain their civil rights and their civil liberties and get the support that they want and need to live their lives. And some of that has been based on Britney Spears's case, and most of that has been based on people who aren't Britney Spears.
Thank you, Zoe. Certainly Britney Spears has brought all this to the attention of those of us who weren't all that familiar with it before. So we're happy to have you here today. Thank you, Zoe. And next, I'd like to ask Suzanne and Richard to introduce themselves. And I would first say a note of appreciation that they're actually down in our Wilmington offices. So welcome, Suzanne and Richard. And if you could each please say a few words about your own practice.
My name is Richard Kiger. I've been practicing law in Delaware for a great many years and involved with guardianship cases for over 30 in one capacity or another, not all that time doing one thing. My interest in guardianship has to do with observing it over a very long period, seeing how it's evolved in Delaware, and I think become much better than it once was. And of course, it can still become better than it is now. I think guardianship is a wonderful thing for those who actually need it. I think it needs to be kept in mind that there are a variety of ways to protect people who are incapacitated in some fashion, and guardianship may not be the correct avenue of approach for some people. We need to keep an open mind about this because there are alternatives that are very worthwhile in considering. Suzanne?
Thank you. My name is Suzanne Soubert. I've been practicing as a Delaware lawyer for several decades. A major part of my practice has been in guardianships, both representing petitioners and also respondents. I stopped acting as an attorney ad litem after the court changed the rule for attorneys ad litem from representing the respondent as though engaged by the person to representing the respondent's best interests. During my practice, I've encouraged clients to consider using the healthcare surrogate statute, decision-making statute, so that they don't have to do a guardianship. And I've had the occasion to work with an attorney ad litem that I believe is coming back to Delaware shortly to reserve a multitude of rights to the respondent and some other limited guardianships and other proceedings. There are occasions, I believe, when guardianships unfortunately are necessary. And I brought with me a couple of examples today if we get to the point where we have time to talk about those.
Thank you so much. I'm sure that we will, and you both raised some interesting issues for us to discuss as we go forward. But first, I'd like to have Terry introduce herself. Welcome to the panel, Terry, and if you could just give a few words about yourself and about EPIC. Thank you so much.
Oh, thank you. Good morning. My name is Terry Hancherick. I'm an advocate in Delaware. This is my daughter, Bridget. Bridget is 34 and has cerebral palsy. I'm also a co-founder of a program at the YMCA, and we're expanding into a couple more places the first of the year for people with disabilities who need one-on-one support in the community, for 3-hour sessions in fitness and health and those kinds of things, and self-determining things they want to do with their day. We don't really have a plan for them. They come in and they tell us exactly what they want to do, what they feel like doing, like the rest of us do when we go to a gym or we go out in the community. So I'm very happy to be here, and I'm really excited about the day. Thank you so much for having us.
Well, thank you for coming, Terry, and Bridget, thank you for coming as well. We appreciate you attending, and we look forward to hearing more about it. I think to kick the discussion off, we'll go to our national ACLU, to Zoe, and ask her to give us an overview, give her perspective on the guardianships and the impacts that they have on civil liberties. Zoe?
Sure, thank you. So at a very high level, and this may be information that a lot of folks on here already know, but just to get us all sort of on the same level, a guardianship is a system where a court is taking away the civil rights, the civil liberties of a person with disabilities. And guardianship is always a disability issue because only people with disabilities face guardianship situations. And when I talk about disabilities, I'm talking about a wide range of disabilities. So commonly guardianships are used for people with intellectual and developmental disabilities, sometimes right when they turn 18. I think Terry can talk about that a little bit, what's called the school to guardianship pipeline. People with psychiatric disabilities and mental illnesses also end up in guardianships, sometimes following some type of crisis. And then older adults who age into disabilities. It's not always, they may not always think of that as a disability, but dementia, Alzheimer's are disabilities. And that's another big population where we see a lot of people being placed under guardianships. And by definition, it's taking away your rights. It's appointing, the court is appointing someone else to hold your rights, your decision-making power for you. And that's a really big deal in our view at the ACLU. That's a harm to take away someone's civil liberties. And I want to be clear that that's not saying that every individual in the system is harmful or is hurting people. There are many very good, totally people in the system who are honest and working with complete integrity, but that inherently taking away civil liberties harms people. And there's a risk of abuse and neglect and exploitation, but also there's a inherent harm in removing a person's rights and liberties. And our view is that people with disabilities deserve to have the same opportunities that people without disabilities have, which is the opportunity to identify and use supports, people they trust, to help them live their own lives and make their own decisions. And too often guardianships are sort of imposed sometimes based on stereotypes about a particular disability, what a person's diagnosis is, how a person sort of presents, or based on what a person can do in a very abstract, isolated setting. So what a person's IQ score is, sitting alone in a room with someone they don't know, can they count backwards from 100 by sevens is like one of these questions that happens in guardianship. Like, unless your job is to count backwards from 100 by sevens, that is not really a way to functionally determine whether a person can live their lives and what supports they could voluntarily use to live their lives. So our hope is to really reduce the number of people in guardianship across the board and take seriously that people with disabilities, like people without disabilities, can use a really wide range of supports to help them make their own choices without losing their civil liberties.
Thank you, Zoe. Very interesting. And I'm sure we'll get more into discussion on the particulars as well. Just a note, if you are getting CLE credit for attending, please make sure you put your name in the chat indicating you're here. There'll be another occasion when I mention that and ask for that as well. Now, Zoe's given us the national perspective, but I want to turn first to Suzanne and then to Richard for a Delaware perspective. Suzanne, you mentioned a change in the law. If you could just kind of bring us up to speed on what the Delaware law is and your thoughts about it. Thank you.
So I think Richard is going to talk more about the protections that guardianships in the process before a guardian is appointed. One of those is requiring a physician's affidavit saying that a guardianship is required because of some areas of incompetency of the respondent, the person that I will call the respondent. I would like to give two examples of guardianships where I think that what they really did was serve what was the original intent of guardianships, which is to provide a safety net as opposed to a jail, and Zoe might want to give the congressional citation that talks about people under a guardianship have fewer rights than those that are incarcerated. But the two examples that I have where I thought it was really important that a guardian be appointed is that a respondent named two of three sons as agents. One of those sons had been bankrupt a number of times. As the mother aged, my client, a petitioner, discovered that the brother, the other agent, had misappropriated over $40,000 over a 15-month period from their mother's bank accounts while living rent-free in a second property. And then as agent, the bankrupt son transferred title in his mother's home to his name alone. And at that point, to stop the bleeding, if we could put it that way, from the bank accounts, we filed a petition for guardianship. In a subsequent case, 2014 case, the respondent, age 75, was hospitalized after a series of strokes, going from the hospital to rehab to a long-term care facility. His, I think, second or third wife kept trying to take him out of the facility against medical advice. There was no way she was going to be able to care for him at home. And so once she was hospitalized and then transferred to the Rockford Center here in Delaware, which is a psychiatric facility, my client, one of the daughters, stepped in to file a petition for guardianship in order to pay bills and make medical decisions on his behalf. The cost of his care was about $10,000 a month. So I do think that there are instances when having a guardian is important. I think it was in about 2009 when I think it was the National Guardianship Association came in and reviewed the processes here in Delaware, and the court made some changes in its processes.
And Richard, could we ask you to speak a bit about what the process is?
The process is that someone who believes there's a need for a guardian can go to the courthouse and to the Register and Chancery, which is the clerk's office for the Delaware Court of Chancery, and talk to people about the forms that are needed in the process for doing this. You can get the forms online. You can also find the laws on guardianships with annotations if you go to 12 Delaware Code, Chapter 39. You do not necessarily need a lawyer for this. You do need a physician, someone who has MD or OD after his or her name, DO, sorry, saying that they've evaluated the person and that there's a need for this, preferably from my point of view, someone who knows the patient and has a case history knowledge rather than someone who's just never seen the patient before, for a lot of reasons that'll take too long to go into here, but I think that's very important. Once that is done, someone is appointed as the attorney ad litem, and that's where I come into it in recent years. I represent the allegedly infirm person. I do not represent anyone else in the proceeding. That's made very clear in writing before I begin my work. And I repeat that sometimes many times to the people involved, just so there's no confusion about whether I'm really there to help them as opposed to the person in question. Most of the people I see definitely need help of some kind because of, it could be mental illness that's gone pretty far along. It could also be other things such as strokes, automobile accidents, violence of some other kind. tumors, brain tumors that affect their ability to think and act for themselves. And a senility of the garden variety senility, such as we're used to, I think it's still correct. We cannot say someone has Alzheimer's. We think they may have Alzheimer's because that can only be demonstrated with an autopsy. So doctors do make that important distinction. So there are people I have declined to recommend for guardianship because after meeting with, I always meet with the person who's at the subject of the guardianship, whether it's in person at the home or at a institution such as a hospital or a nursing home. If it's at someone's home, I always make an appointment because I think that's only right. If it's any other place, I just show up because I don't want someone preparing the person to meet with me, making sure that the meds are what they should be at that particular moment. They're cleaned up more than usual, whatever. I want to see what they look like and have a chance to talk with them. I prefer to talk for at least half an hour if that is reasonable. Sometimes it's not. If you're in a coma, there's no point. But at least I've learned that if you have Alzheimer's, allegedly have Alzheimer's, you may present very well at first. So you need the extra time for the person to decompensate and get a feeling for whether there really is a problem here, as opposed to someone who's in great shape and who's being railroaded. These are practical considerations that have led me to do this. My follow-up is I talk to everyone I can find who has an interest in the proceeding. That's typically family members. Occasionally, there is no family member at all, so I have to talk with the individual, the friend, who is applying for guardianship. By and large, the people who do this understand what they're getting into and are doing it because they care deeply about the individual. I won't say that's true in every case, but most of the cases I've seen, there have been times I have had misgivings about the person who applied for guardianship and the reasons, and I have asked that the matter be dismissed. So I think the attorney ad litem plays an important role here, looking out for the wishes of the individual and representing those wishes if they can be determined. If not, it becomes a question of what may be in that person's best interest. It should not be forgotten that guardianships can be terminated. If you have a brain tumor that can be removed successfully, the problem may go away and then you can have that terminated. And there are other instances of this also. If you recover from a car accident, you come out of your coma, so on and so forth. So these are very important. The situation with the court system is they take these things very seriously. And the paperwork has to be just so in order for it to be presented to a judge. The petitioner has to come before the judge, and the judge gets to see what this person looks like, acts like, how they speak, whether there's anything that's off-putting. Family members, other interested parties also have every right to take part in this and agree or object and give their reasons for doing so. There is monitoring that goes on, primarily of a financial nature to make sure that assets are not being dissipated or embezzled or whatever. But in addition, if there's any question about further examination of the individual by the attorney ad litem or by a physician, that happens. I've been called back a number of times when there's been a question about whether the reason for the disability continues, or alternatively, and very seriously, whether the person who is the guardian ought to be removed for whatever reason. It may not be that there's been misconduct, but maybe someone in the family who bears a grudge thinks that he or she would be better in the role. These things do happen, and then you get into issues of visitation. So there's a lot of attention that is paid to these things by me, of course, but also by the judge. The one case I'm thinking of right now, there's been multiple teleconferences with the judge to discuss visitation, vaccination, all these things. The person who wishes to be guardian doesn't believe the vaccination and doesn't want her grandmother to have the shot. The rest of the family, including the guardian, think that at her age, with her multiple problems, she needs protection. And a large part of this is stemming from the issue of vaccination, but also personalities that are in conflict here. So I think there are many protections. When I read about what happens in other states, and lawyers in other states tell me what has happened in their cases, I'm horrified at times. And you can read some of this in the New Yorker. I think the writer is Rachel Aviv, A-V-I-V, who writes very powerfully about this. In recent years, there's also been articles in the New York Times, lengthy articles in the Sunday Times, describing what happened in the guardianship, why it happened, and why it could have been prevented. So all these things come together, and I think Delaware is in very good shape, but I'm not prepared to say it's in the best possible shape, because as we learn, there's always room for improvement.
Thank you, Richard. That's very helpful and very interesting. And it certainly sounds like there's a lot of complexities to the matter. I'd like to turn now to Terry to give us her vantage point, having been personally involved. Terry, if you could go ahead and say some words about your own experiences and your daughter's experience.
Absolutely. And my daughter has used her decision-making ability to say she does not want to be here. She needed to get out of her chair. When Bridget was transition age, which is close to age 18 and ready to leave school, during the IEP, guardianship is always brought up. So I was told that if Bridget were in an accident and we weren't with her, and say she was on a bus or something and something happened to her and she went to the hospital, she would not get medical care because there would be no one there to sign, and that we couldn't sign because we didn't have guardianship. None of that was true. No one lied to us. It's just what the school system knew, and it's what they believed, and I believe they still believe that. Many school personnel, many doctors and nurses and many medical personnel do believe that. So of course, when we heard that, my husband and I ran to get guardianship for Bridget because we wanted to protect her. That's what we needed to do, we were told. So we did get guardianship. We actually did our part ourselves. And then we went through, I think Parent Information Center at the time was offering instructions on how to get guardianship. So we did that and we paid for an attorney. The court appointed an attorney for her. It was $275. The attorney came and spent 10 minutes with Bridget. Bridget is nonverbal. She doesn't use technology at this point. So she really doesn't have a way for people who don't know her to communicate. People who do know her communicate very well with her. I know her wants, her needs. She's able to convey that to me. She's able to convey when she does or doesn't want something, or doesn't like something. She chooses her meal. She makes a lot of choices throughout the day. And it's just a matter of listening to her. But those outside of the home would not be able to understand Bridget's communication without spending more time with her. So in 10 minutes, the lawyer left and said and recommended that Bridget be under guardianship and that she was incapacitated. So within a couple of weeks, guardianship was awarded to my husband and I. Bridget never went in front of a judge. Bridget never went to court. No one saw Bridget except for that one lawyer. And we thought we were doing the right thing. And then as I got more into advocating and Bridget got a little older, and I listened to people like Jonathan Martinez, and I listened to people like Ari Naiman and these names out there who are national advocates. And I was at national conferences and I heard how really Bridget wasn't a real person anymore. And it was true. In many states, she wouldn't be able to vote. She votes here in Delaware because we discuss it and we talk to each other, or I talk with her and I discuss well, how about this candidate? This candidate does this for disabilities, and this is their platform and this. And I think she understands. I truly believe she understands. And I help her with that. And she is able to make a choice. And it's not always my choice. As years went by, I just thought it just was the wrong thing to do. And what really happened was when I went to the bank and I wanted to get her own ATM card with her name on it. I want something with her name on it that I could help her take out of her purse or her wallet when we went to a store. I just wanted her to have some self-determination and some control over her life. So when I went to the bank to ask about getting her an ATM card, I was told, no, you can't do that. Do you have guardianship? And I said, yes. desk. They said, well, you can't do that. So I cried all the way home. I'm like, oh my gosh, I've taken everything from her. Her name means nothing. She will have nothing that's hers. It's all under our name. So I got home and I called the Chancery Court and they said, no, you don't have financial guardianship. You only have guardianship of self. So I took her back to the bank and we talked to the person again. And they were like, okay, well, that's fine then. Can she sign? I said, sure, I need to help her, but she can make because of her because of cerebral palsy, she can make a line and that is her signature. So she signed and she did get her bank card. So now she has a bank card in her name. It's those little things that really mean a lot for people. I didn't want her to have nothing in life. I wanted her name to mean something and I wanted her to be able to use her name in her own decisions. So after that, we spent a lot of time, a couple of years going through the Chancery Court and asking that Bridget be relieved of guardianship, or that we be relieved of guardianship and Bridget be on her own. They understood what we were saying, but they said, once that you tell someone that tell the courts that she's incapacitated, how are you going to prove that she's not? And so we did get a lot of help from our Office of Public Guardian. Alexandra McFassel was very helpful to us. Jonathan Martinez from Virginia, who is not licensed here, but he did help us by consulting with us. And so we went back and forth, and eventually the court did change the rule so that we could go to a lesser form of guardianship to help with her decision making. We now have surrogate decision making, which helped us. We would like to get to supported decision making, and we're hoping to get there one day. But I think that the big issue is that families are not, when you're at that IEP and you're at the transition IEP, instead of the school system saying you need to go get guardianship. And by the way, I've never been asked for guardianship papers for Bridget ever. So instead of the school system saying that, they need to present you with a list of there are 4 other alternatives besides guardianship. And that list needs to be presented. It goes from guardianship to supported decision making. And how can we support someone with lesser with a lesser decision making power from guardians? And instead of having guardians, how do we do something different and still support people in their decisions and allow them to make decisions with the amount of support that they need? And I think that's what's missing especially from the school system. It is, as she said, it's a pipeline to guardianship, and it really shouldn't be.
Terry, thank you so much. Really fascinating to hear your experiences with the process, and also fascinating for you that you identified certain of the flaws in it, where we have the schools really being a source of misinformation. And I'd like to kick open to a broader discussion on that very point. You know, where are the weak points? Where is it that the process is breaking down, not serving a beneficial purpose, and needs to be altered? So I guess it's just for clarity, why don't we start with you again, Terry, if you have more thoughts on that, and then go to Zoe and Suzanne and Richard. And if you could all weigh in just on where you think these processes should be improved.
It's an education issue. It's an education for as much as banks, medical facilities, and especially schools. And it's a change of mindset. The guardianship has tripled since 1995. So that's 1 million more people. Why are we doing more guardianship when we have technology, we have waivers through the disability system? We have all kinds of things to support people in the community, and yet we have more guardianship. So I'm not understanding why that's happening. I think it is an education issue that people can be supported, and people also deserve the dignity of risk. We all learn from our own mistakes. Guardianship is not going to protect my daughter from sexual abuse. It's not going to protect her from any kind of abuse. What's going to protect her is being in the community, having friends, and people noticing when something's wrong, or people noticing that Bridget didn't show up today. I wonder what's wrong. And people question that. Guardianship protects you from nothing.
Well, that's a very important point. Fascinating. It's fascinating that it's gone up so much. That was one of the things I was thinking about as Suzanne and Richard were talking, like how many people in Delaware are in this status. And Zoe, perhaps you could say a few words just about whether we're seeing this nationally, this increase in guardianships, your view on that, and where you think the process could be improved.
Yeah, sure. I mean, one of the problems with guardianship is that we do not have nationwide data about guardianship, and it's a real problem. There's a pending bill in the Senate that Senators Casey and Collins introduced to get data on guardianship across the country. And it's a problem that we don't know how many people are in guardianship because that data is important. It's also, I think, really striking because we count things that are important to us, that we consider key information. And I think it's really striking that as a country, as a society, we have not considered that something that we need to have the answer to. So nobody knows how many guardianships there are across the country. And that's really concerning. In terms of what needs to be improved, I think my view is that there are changes that do need to be made within the guardianship system. For example, people are not across the country entitled to having an attorney who represents them in guardianship. People are, even if they have an attorney, sometimes attorneys represent or advocate for what the attorney thinks is the person's best interest rather than the person's stated interest. And that can be a stated interest, even if you don't use speech to communicate that people who are not disabled have a right, like Terry was saying, to make bad choices and learn from them, and that people with disabilities should enjoy that same right. So there are changes within the guardianship system, but really what I see as the key thing that needs to change is a real transformation to get far, far, far fewer people anywhere near the guardianship system to begin with. And so what I see is that we really need to transform systems of voluntary support and disrupting pipelines like Terry described. This, we hear about this all the time in schools, that people are told that they have to get a guardianship when their child turns 18. And one of the things people don't realize about guardianships is that they are often very, very hard to get out of, especially if the person is not cured, quote unquote. So sure, there are disabilities that you might recover from and not have a disability anymore, and then you should get out of guardianship. But there are many people, perhaps most people with disabilities, whose disabilities are lifelong. But that doesn't mean, and that is a place where it's very, very hard to get out of guardianship if you are still a person with disabilities, but you've put in place support systems so that you can voluntarily get to the place where you have capacity, which is a very complicated concept and nuanced concept, to make your own choices. So what I really see as what we need to change is huge reduction in the number of people going anywhere near guardianship, and have a much easier systems for people to get out, and also systems for people to get supports, and for families, for people around them to have the information they need to understand what choice they're making if they choose to pursue guardianship. Because I think, it's very common that people don't know what the alternatives are, and that, what I would love to see are judges who would reject guardianships, who would say, if somebody comes into the court and says, I want a guardianship, and the judge says, well, what else have you tried? Before I take away this person's civil liberties, have you tried supported decision-making? And if people haven't really tried it in good faith for a real period of time, I would love it if judges said, no, come back to me in 6 months. I'm not going to take this drastic step, this last resort step, before you've tried first resorts, voluntary supportive options.
Thank you, Zoe. It's very interesting, and it strikes me that there's really the two pressure points, that the schools are a source of the kind of pressure towards guardianship. And then, of course, we have the judiciary, and we have the way in which they're responding. On that, Richard and Suzanne, I would be really interested to hear, and I encourage all of the participants, please put any questions you have in the chat. Richard and Suzanne, I'd be very curious whether Delaware also has seen this dramatic rise in the number of people under guardianships, and then your views on, you know, the schools and the judiciary, and what are the changes that should and could be made, or whether you think it's functioning properly.
You want to go first?
I can go first. There are statistics that are kept, but I have not seen, I don't need to see them in recent years, but the annual report on the judiciary comes out each year. Probably the next one will be out in December I think it's for the fiscal year ending September 30th. And it goes through the caseloads of all the courts, what came in, what was dismissed or terminated, whatever. So you can see how many guardianships were filed in each county during the preceding 12 months, and how many were terminated in many cases because of the age of the person by death, but also this would reflect cases that are terminated because the person got well and there was a request to terminate the guardianship. I'm not sure that it's broken down more than just saying we terminated these and gives a reason. It should, but I'm not sure about that. I have not seen the cases for a long time, the statistics for a long time, but these have been kept since, I would venture to say, 1972. Something else in response to what Zoe said, the petition for guardianship specifically asks if it is known that the individual has a durable power of attorney appointing someone to act for them. And that's a critical question. Presumably, you would hope that the person knows about what's going on and can step right in, but that may not always be the case for any number of reasons. And the person may have died and not been replaced in the document. But that is a critical issue. Is there someone else the individual has selected to take care of me and speak for me in crises such as this? In terms of the what goes on in the guardianship interview between the attorney ad litem, I am required to ask, assuming we're not talking with someone in a coma, to explain the basic ideas of guardianship, personal guardianship of the person and guardianship of the property, and then try to discuss that if it can be done, and also ask, do you understand what I've been trying to say to you? Sometimes they say yes, sometimes they haven't a clue and couldn't care less. And then I always have to ask, and I do ask, is it okay with you if your daughter, son, wife, child, whatever, whoever it may be, is the person in charge, or would you rather have someone else? So at least that is on record. If I don't do this and put it in my report, the report will not be acted on until that correction is made. In addition, there are things that Terry said that give me an opportunity to bring up some matters I hope to anyway. In terms of doctors and what goes on in a hospital setting, many people have said to me that, especially with an autistic child who has had lifelong problems and become an adult, I can't talk to you, your child's an adult, I can't even discuss the case with you, go away. And the first time I heard that, I was skeptical and thought there must be a misunderstanding. I've heard it many times now. Usually it gets worked out in an emergency setting, but that's something that drives people to get a guardianship for their child, especially the nonverbal ones, because they just feel that they're at risk. The doctors will not talk to them about it, and the doctors don't know what they're doing. The family members will often say, why don't you talk to his primary care physician? And you will find out he has never spoken to anyone. And without us, you're not going to know anything about him. The other issue that comes up repeatedly with people over 18 into their 20s and 30s is usually when I'm seeing this, the person who's in charge, usually as the guardian, is usually the parent, one or other or both. And they have a thorough knowledge of the child's medical history. And you find out that often the caregiver, the person providing care in an institutional setting, hospital or nursing home, doesn't seem to know what's in the chart and wants to do things that have proven disastrous in the past. So you get into these arguments. If you're the guardian, you've got a lot of leverage to say, we're not doing that. If you're not the guardian, you don't, and they may give a drug that has been really horrible for that individual and provoke serious reactions, or they may try a course of treatment that, again, is very, very bad. I've seen situations where someone has been told at the hospital, well, it's hopeless, go home, call hospice and make your funeral arrangements. And the parents won't accept that. And they demand another opinion from another hospital where you get a different diagnosis and the patient gets well. So these are important things, but the guardianship, I think, is what gives leverage in these cases. And it's a situation that I've seen where I think the guardianship is needed and an alternative probably would not be as effective in dealing with the dominion culture, as it's called in sociology. Did you have, go ahead.
Suzanne, did you want to add anything?
Well, I'll try to be quick. So I've talked about guardianships as being a safety net, and you've got the guardian who's supposed to act as a fiduciary in the best interest of the respondent. You've got the court who's reviewing both financial and also on an annual basis, the physical condition. And because notice is given to interested parties, I've usually thought of that as being the third leg. However, especially because we've got this one attorney coming back to Delaware, I've heard in the attorney ad litem position, who is, his specialty is what I would call special ed or education law. I'm really encouraged. Well, and the other thing is the court doesn't want more guardianships. You know, our Court of Chancery is the corporate court for the nation, and they really want to give people options other than guardianships, which is one of the reasons that they were very supportive when the supported decision-making statute was passed. But one of the things, if I can go through quickly, some of the rights that this one particular attorney ad litem made sure that we enumerated in the final order. I'll just try and be really quick. It was really helpful. One was spelling out for the respondent to seek termination or modification of the guardianship by written request to the Court of Chancery. And I've represented a respondent who after several years wanted to terminate. And so I've represented her in that role. To have and spend her own money, to enter into a contract, to own and drive an automobile, to engage in educational, vocational, leisure activities, select her own friends and decide when, where, and how to communicate with them, to marry whom she pleases, to vote, to become as independent as possible, to apply for government benefits, and to participate in all other decisions. And then, so that was a young person coming into a guardianship. And I'm not a special ed lawyer, so I don't know what the respondent is capable of. More often I've been attorney ad litem for adults, and it is very common for me to make sure that the adult retains the right to have either a weekly or monthly allowance that they can spend as they wish. I had one case where the respondent wanted to spend his money at Delaware Park. Okay, not my choice, but that's where he wanted to spend it, so okay. And I've also made sure that the right to be legally represented by counsel of her own choosing has been included in an order. And in one case where an 80-year-old came in and said, somebody's trying to get a guardianship over me, so this is a respondent I represented without being appointed. And it's, I guess, maybe one of the few cases where I finally said to the court, my client needs a guardianship to protect her from petitioners. And we had neighbors of hers step in to become guardians, and we made the petitioners waive the right to have access to information about her financial situation.
May I jump in on that?
That's very useful, practical information. And I think the listing that you gave in particular was very interesting and keys in with a question that we're seeing from one of our participants, which is about voting, whether people who are capable of voting but are under guardianship are able to vote. Terry, is your daughter able to vote? And then I would kick it to Zoe to ask that question nationwide.
She is able to vote because she's not under guardianship anymore. It was terminated. I do believe, and I'll send this to the attorneys. I do believe in Delaware, you're still able to vote under guardianship. Many states you are not.
Thank you.
Mhm.
Yeah, this is Zoe, just echoing that it varies state by state. In California, where I'm based, you have to have there's a specific extra process you have to go through to take away a person's right to vote, because that's such a big imposition of civil liberties. But so it happens less often than it did. But one of the things that we do see across the board in terms of guardianship is that these kinds of limitations, like Suzanne talked about, which are really valuable, are quite rare. That it's very much more common for people to get what's called a plenary guardianship, where you lose all of your rights, than to get what's called a limited guardianship, which is like what Suzanne is describing, where a lot of rights are reserved. And even in cases where say a parent seeks a limited guardianship for specific reasons, courts can say, fine, I'm granting the guardianship, but I'm making it plenary. And there's not really anything that can be done about that. And I think that's part of the, really how risky the situation is. It's not an equally good way to protect a person. And I think, there are a lot of what studies show is that what really keeps people safe is self-determination. It's having the opportunity to say, no, I don't like this, and having that taken seriously. And that is not taken seriously necessarily if you're in a guardianship.
Well, and it's interesting, the notion of the different levels of guardianship, as well as you had made some reference to supportive decision-making, surrogate decision-making. Could you, for our listeners, just kind of tick us through what the hierarchy is? I assume the plenary guardianship is the highest level, but what comes below that?
Yeah, so plenary guardianship is that you have no rights. You have suffered what's called a civil death. You have no individual rights to make your own choices, just like Terry was saying. It's like her daughter had disappeared. That's, I think, quite compelling, or didn't exist anymore. Then there are limited guardianship, where you've lost the right to make certain choices, but not other choices. But then there's a whole universe that's really underused and that a lot of people don't know enough about, which is the court isn't involved at all. You are getting support using mechanisms that allow you to have help understanding, making, and communicating your own choices. And power of attorney is a very, common way to do that. Authorizations to share information. These stories we hear about hospitals and doctors refusing to interact with people without a guardian are just absolutely wrong. Like, that is not that they're wrong. They're definitely happening. I'm not challenging that, but that is not how the system should work. There should, people can authorize whoever they want to see their medical records, to participate in their decision-making through a HIPAA waiver or an educational authorization to share information. And then supported decision-making is sort of encompasses that as well, as a way to choose and identify people who you want to help you, support you in making your own choice, and you still retain your rights. And another very simple tool that a lot of people, perhaps many of us on this call, use is technology as well. Like, smartphones are such an incredible access tool for many people. Like, if you have set a reminder on your phone at 9:30 every night to lock the door, that might be what the difference between being able to live safely on your own and not. And that's, 1,000 times less intrusive than guardianship.
Thank you, Zoe. Very helpful. And I guess to my own mental list here of where we need more education, we put hospitals on the list, as well as the judges and the schools. Terry, anything I'm missing from that list from your vantage point? Are there other, system failures, other parts of the system where we really need to get out there and educate folks?
I think we need to educate people with disabilities on self-determination, because if people with disabilities are able to make mistakes and to have some self-determination, they're also better able to recognize and avoid abuse. than if they're under a guardianship, and they're more likely to live on their own and have a job. And we know all of that. So, yeah, and so as far as hospitals go, maybe it's because Bridget is nonverbal that when I've never been asked for guardianship papers, like I said, and they always defer to me and say, you know, I have never been stopped from saying anything or asking for anything or making decisions for Bridget. So, and that may have to do with the severity of her disability, that, which is good or bad. It's probably bad that they look at Bridget and think that she can't make decisions. So they just come to me and ask me. So it's good in a way that I'm able to make the decisions, but I'm not happy that Bridget, because of her disability and the severity of it, is not thought of as someone who can make a decision.
Thank you, Terry. We only have a few minutes left here, and I want to direct this to Richard. First, Richard, I think that you were going to add a comment earlier, so I wanted to give you an opportunity to add that. And then also I wanted to get your view on probably the most famous guardianship of life, the whole Britney Spears thing. And maybe we can end the panel with just everyone kind of weighing in on what made national news, and certainly, speaking for myself, educated me more than I had been before about the whole concept of guardians. Richard?
The comment I was about to make in adding to something Suzanne had just said is, I've seen a handful, very few cases, where the person who is going to be the subject of the guardianship asked to have a guardian appointed. These were financial situations. As far as I know, there was no physical abuse, but there was emotional abuse. You don't love me, you always love some blah, blah, blah. And the person would collapse under this and write a check. And it was foreseeable that they would end up destitute, but they could not say no to the loved one. So they found a lawyer and were able to, under Delaware's law at the time, which I think is still the same in that respect, they were able to have a guardian appointed for themselves, because that way, that would take away any possibility without court authorization of the person getting their hands on the assets, mortgaging the house, whatever.
Selling it.
Yeah, these things happen, and they're pretty horrible, and you can't really fix things afterwards when that happens. With respect to Britney Spears, I have to reserve judgment. I have a strong, I don't know what to think, but I have a very strong feeling that the propaganda machine has been working over time to create the desired image that will make her sympathetic to us, which may all be true, but I don't feel I have enough information to offer an opinion.
Richard, thank you for that lawyerly answer. And lawyers, I want to make sure everyone remembers that if they're getting CLE credit, to please add in their name again. And then Zoe, Terry, Suzanne, anyone want to add some final comments on Britney or anything else before we close up here? And let me thank all of you for participating.
I can jump in briefly on Britney Spears. I wrote an amicus brief on behalf of her in this summer, advocating for her right to choose her own lawyer, which was a big issue that she said she did not want her current lawyer. I think I don't know anything that's not public about her, but I think that she is someone who may have a disability, is certainly being treated as by the court as having a disability, and who is describing a situation that sounds really common, that she is being, in a situation where she can't direct her own life and she doesn't like it. And I think that should be taken really seriously. And so I think, I think her case is very emblematic. Of course, there are things about Britney Spears that are not like any of the rest of us, but there are also things about her case that are very, very common.
Thank you. Terry?
For me, it's very scary that someone like Britney Spears, who looks and sounds like they do not have a disability, or that, they have a very slight disability, and you can't tell that by looks. And then you compare my daughter, who has a very obvious disability. It scares me and it should scare parents that someone like Britney Spears can be put under conservatorship and have some of her rights taken away. How quickly that can happen to her, how quickly it can happen to our kids especially. So that's the part that scares me. You know, so many people that have self-determination and are able to make their decisions so freely and so obviously, when someone like my daughter can't. Obviously, to people, it looks like she can't make her decisions when she can. If we're taking away someone else's rights, that's very scary for me.
I think that's a perfect note for an ACLU program to end on, about how scary it is, the awesome power of the state. Oh, Suzanne?
Yeah. So I would like to just comment that psychiatric issues are very difficult, and I don't know enough about Britney's situation to know. I mean, I would like to believe in Delaware that the guardianship would have been terminated many years ago. For the lawyers that are attending, the surrogate decision maker for healthcare is in Title 16. Chapter 25, and the supportive decision making is in Chapter 94A. So if people want to go look those up, that now they'll have some resources. Sorry.
Thank you. No, thank you. Very, very helpful. And I'm assuming that a fair number of the folks on are attending for CLE credit. And I just wanted to thank all of our panelists for sharing all this important information. It's certainly been educational for me, expanded the little I knew, which was just from reading about Britney Spears. So thank you. Thank you all so much. And let's all give a round of applause to our panelists Zoom-wise. Thank you so much.